220778 and file 220779. Please state your appearances for the record.
Chris Fleming, appearing on behalf of the people.
Good afternoon, Judge Morgan. Good afternoon, Mr. Fleming. Stephen Crosswick, self-represented pro per.
This is a motion hearing. I believe it is Mr. Croswick's motion. Sir?
Yes, it is.
I've never received a copy of any motions, Judge. All I have is a notice of hearing and motion, and there's nothing to it.
I believe at the last hearing, Mr. Bayento confirmed that they did get notice.
Notice, yes, but we don't have the actual motion.
We have the notice in the file.
I believe it's sent certified mail from the Adrian Post Office.
For the notice, it says motion to dismiss case on grounds lack of probable cause and lack of evidence presented by the prosecutor in these cases. The defendant, Stephen John Croswick, is requesting the court dismiss these charges with prejudice is misspelled, but it is, I take it, prejudice.
I apologize.
I don't have anything further in this file either, other than a notice of hearing and motion, and then what I just read for the motion. Is that all you have, Mr.?
That's all I have, Judge.
And then I should state that is the only thing I have as far as the motion, unless there's something else. Mr. Croswick?
I'm just trying to understand what you're saying.
Your papers are on the,
I apologize.
so in other words, it makes a great deal of ruffling sound.
I understand. So you're saying he didn't receive the motion that I sent, certified mail? Is that what they're saying?
What, do you have a copy of that motion?
If I don't have it with me here, yeah, right here. So here it is.
You can show it to Mr.
Yeah, no, we have that. Here's the problem. It needs to comply with Rule 2.119. I don't know what you're arguing in that.
What am I arguing? He's just said that there's no probable cause in these cases and lack of evidence.
Yeah, but there needs to be facts.
I'm ready to deliver the facts.
In a motion itself.
Okay, I'm ready to do that.
But it needs to be in writing beforehand so I can respond to it beforehand.
Okay, I guess I can submit it in writing to the prosecutor.
I'll leave it up to the judge, but
I guess it would be on the judge's discretion.
Well, with what has been presented, as stated, lack of probable cause and lack of evidence presented by the prosecutor in these cases. These are, and I should note, these are both misdemeanor cases. An exam is not required in this case or these cases.
I would just note also, Your Honor, the prosecutor determines a probable cause standard to charge. We have determined that the evidence doesn't need to be shown at this point. That would be shown at trial if it came down to it.
Obviously, Mr. Croswick is entitled to discovery, but Mr. Fleming is correct as far as his presentation. I would also state that Mr. Brooks is in the courtroom. Are you a witness to this, Mr. Brooks? Or
This is the third time I've been invited into this hearing.
And who's...
I don't know. I got a document that said I am subpoenaed to be here. That's what
Who subpoenaed you, Mr. Brooks?
I don't know.
Do you have that with you?
No, I didn't feel I needed that. I just figured you need my presence.
I take it the prosecutor has not provided any subpoena to Mr. Brooks.
I did not see any issued for today, to be honest with you, Judge.
Mr. Croswick, did you issue a subpoena for Mr. Brooks?
Absolutely not.
Then may Mr. Brooks be excused.
Absolutely, Judge.
Thank you, Your Honor.
Then Mr. Brooks, as no one is claiming they've given a subpoena to you, you are excused from these proceedings.
Hopefully I will not be subpoenaed in this matter again.
Very much so. Mr. Croswick, this is your motion, so I'm going to let you at least make what would be considered an opening statement. However, I have to state, Mr. Fleming is very correct as far as a motion would need to have some specificity as to what exactly is being argued. But I will allow you to make an opening statement.
My opening statement is that I filed a motion to dismiss these frivolous charges brought by the Tecumseh Police Department. There's a lack of probable cause for the arrest they made to arrest. There's a lack of evidence in both of these cases. If this ever does get to trial, which I don't think they'll ever take it, they're just holding this over my head. This incident happened in January of 2022. It's been adjourned 5 times, I think, from trial dates. I've shown up for trial and it's been adjourned. Now, at the last trial date of 9/13/2022, in Judge Shaler's court, it was adjourned because witnesses were not present. The witnesses were sitting behind me. I FOIA requested the security cameras from the hallway, and I have evidence that they were there. Mr. Fleming talked to the witnesses that day. So did my attorney, my former attorney, Mark Linton, as well as some other court staff, talked to the witnesses that day. And it was adjourned because they weren't present. I would like to proceed, if it would please the court, and present my argument why these cases should be dismissed.
Is there anything else, sir?
That's it, sir.
Mr. Fleming, do you have anything you would wish to say at this time?
I think it's a mischaracterization from, let's see, I think it was September 13, I believe, trial was scheduled for, or September 13th. It was my understanding at that time that the defense counsel was not ready to proceed. That's why it was adjourned. Also, it was further on down the list. Judge Shaler scheduled quite a few cases for that morning. So that's why that was adjourned. All the witnesses were here. Mr. Croswick was correct on that point. Then his attorney filed a motion to withdraw, which was heard, and he was removed as his attorney of record. That was the only time it was actually scheduled for jury trial, I believe, at least in the 7-8 case. I haven't looked at the other one, Judge. More to the point, I mean, probable cause is determined by the prosecutor in charge of misdemeanors. The prosecutor's office, whoever authorized these charges, determined that there was probable cause to charge it. As far as evidence being presented that occurs at the jury trial, so there would be no evidence produced at this time. There's been no cite by Mr. Croswick as far as any statutory authority to dismiss these charges, and people would request he deny his motion to dismiss.
I'm sorry, do I get to speak to what he just said? Do I get to?
I'm going to grant you a brief moment, so you have limited to 3 minutes maximum, but I will allow you to respond.
Okay. He said it was only dismissed, or it was only brought to trial a couple times, 1 or 2 times. He left out the fact that it was brought to trial in April, and it was dismissed because the witnesses weren't available at that date, and then the charges were reassigned. He left that out. Thank you.
Thank you. Mr. Crosvick, Mr. Fleming is very correct as far as probable cause in misdemeanor cases is very much in the preview of the prosecuting attorney's office, their preview. Lack of evidence, evidence is most definitely presented at a trial, but the court is a neutral arbiter, so evidence is not provided, such as police reports are not provided to the court because quite literally that's an awful lot of hearsay. And the court doesn't make any determination as to whether there is or isn't evidence. That would be for a finder of fact, which would be a trial, which would be the jury. Probable cause falls within the preview of the prosecutor, and whether or not there is a lack of evidence would fall within the preview of a jury and the finder of fact. So this court, based on what has been presented and what is before it, is not able to grant your motion. So I would deny your motion on both file 220778 and 220779 at this time.
Can I ask the judge a question?
You may.
Am I able to file another motion and include the language that he's looking for in the motion before the trial?
Well, you are representing yourself. You
Yeah.
most certainly can file motions. I would just reiterate, although you're representing yourself, you're still bound by the rules of evidence and the decorum of the court.
I understand.
So if the motion is found to be frivolous, then it will go forward at that. I know you had an attorney previously. I cannot stress enough that an attorney sometimes gives a great deal of insight as to the workings of the court. And as stated, you will be bound by both the rules of evidence and the decorum and how the court operates. So you do need to understand that. I'm not going to tell you can't file motions.
Okay.
Obviously, that is, you can file motions. But if the motion predominantly is what was presented today, the court would still not be able to grant that.
Okay.
Is there anything else that either party wishes to present at this time?
I look forward to my day in court with a jury of my peers.
Mr. Fleming?
Nothing further, Judge.
With that, the motion presented by the defendant, Mr. Croswick, and both files is denied, and that is all for today.
Thank you, Judge.
Thank you, Judge.
Court's in recess.
All rise.
Thank you.
You're welcome.
Yeah, that's scary.